Hello, I'm Blake West with the Alabama Estate Planning Attorneys. Thank you for viewing our webinar. We're going to be talking about what happens to my assets when in this webinar. This will teach you some ideas about estate planning, what happens with and without that. And here is our PowerPoint. And this is where we are. We're across from Bridge Street in Huntsville. We also have an office in Coleman. The agenda, we're going to review some scenarios with and without planning. We'll do that by talking about different families that you will likely know, even though they're fictional. We're going to discover ways to direct our assets with various types of families and after we're gone. We're going to learn how to protect our assets now and in case of incompetency, a blended family, and after death. All right, the first one we're going to look at, the first family, is Barney. Barney was a deputy. He had one bullet and one gun. So what happens when Barney dies without a will? Now remember, Barney is single. He has no children. He has no planning at all. So what happens when Barney dies? Someone has to go to probate court and say, hey, probate judge, I need to take care of Barney's affairs and wrap up his business. Okay, you need to file a petition. And in that petition, you have to say who are his next of kin, who are his legal heirs, when did he pass away, where did he live, and roughly what you know about what he has in assets. Also, you will need to file a bond. A bond is insurance in case Andy steals the money from the people that are supposed to have it. After the probate judge says, okay, Andy, you're the person, you're the administrator of the estate, then there's a publication. That publication is in the newspaper, and it says Barney died. If he owed you any money, you have 6 months to let us know, or else you won't get it. So that creates at least a 6-month delay before any of the money gets to the heirs. After he's appointed, also, he will have to file an inventory, which is a detailed list of everything that Barney owned and Andy's estimate of the value. If there's any question of the value, then Andy would need to obtain an official appraisal, like a real estate appraisal, an antique appraisal in some cases, or whatever he might need. This being administrator of an estate, especially with no will, comes with a lot of court oversight. If Andy needs to sell the house, he will have to ask permission of the probate judge to sell the house, and the price will be set. If he needs to sell his car, same thing. He has to have permission from the probate judge. If he needs to sell his furniture in the house, clothes, anything he needs to do, Andy would have to ask for permission from the probate judge to do that. It's very cumbersome, time-consuming, and can be quite expensive to do all those things. Once those things get done, and we're past the 6 months, what happens? The money goes to the creditors. They get paid. Anyone to whom he owed money. We do this using the state's rule book. The state's rule book is important. It's the probate code. And if you do not have your own rule book, such as a will or a trust that we'll talk about later, then you have to use the state's rule book. The state's rule book is a one-size-fits-all. And there's not really any such thing as a one-size-fits-all. If so, we would all wear the same size pants. But that would not work out very well, would it? All right. So now we've gotten through the 6 months through probate court with Barney with no planning. We've paid the creditor. So anything left, where does that go since he didn't have a will? First up would be his parents. It would go to his parents. All right. Who gets left out of this situation? Thelma Lou. Thelma Lou gets 0 because they weren't married and he didn't have a will. So poor old Thelma Lou, put up with him all those years, gets nothing. Okay, again, so we've gone through our 6 months. What if Barney's parents died before him, which is the most common thing, our parents die before we do. Then it would go to the issue of his parents. Issue of his parents is lawyer talk for brothers and sisters, meaning it would include half brothers and sisters as well. So the half sibling takes the same as the whole. All right. Now, what if Barney, the same one, what if Barney had some planning? What if he had a will? You still have to go through probate court. You can omit some of the court oversight with a will, which is very helpful. So we'll go through probate court. We still have to pay the creditors and those kind of things. But anything left this time, it can go to anyone Barney wants to name in his will to leave it to. So he could leave it to Thelma Lou or Skippy. Now you're thinking, well, who is Skippy? Do you remember Skippy? Skippy was one of the fun girls from Mount Pilot. So maybe he wouldn't leave it to Skippy, but maybe he would leave it to Thelma Lou or Andy or some charity, which would be much better. Okay, we've talked about that, and we mentioned a will. This is a good time to mention some things that a will does not control. This causes a lot of confusion. A will does not control beneficiaries for life insurance, an IRA, 401k, those kind of things. If you have a named beneficiary, that will pass outside of probate court. If you have a life insurance with Protective Life, whomever you have as a beneficiary, Protective Life is going to issue that check to that person. And let's say you have 3 kids, you name your oldest child as beneficiary, that's Junior. But in your will, you say, I want my life insurance split 3 ways. Protective Life is going to issue that check to Junior. What's Junior going to do with that check? Is he going to split it 3 ways? Maybe, maybe not. He can't be forced to do that. He wants to put it in his bank and keep it, he can do that. Pay on death. Many financial accounts now, the bank or whomever ask you for a pay on death designation. That means as soon as you die, if it's a joint account with husband and wife, then as soon as both of them are gone, then the money in that account goes to the pay on death person named, sometimes called transfer on death. And that happens without probate court. Again, the will says I want it split between all my children, but you have Junior named as pay on death. Junior gets all that money. Will he share it? Hopefully. Does he have to share it? Absolutely not. All right, joint. Very common. If you're married, you have a joint bank account. So when one of you dies, it all belongs to the other one. If you're married and own a house, the deed to your house is very likely also joint tenants with right of survivorship, meaning when one of you pass away, the real estate belongs solely to the other one without anything happening. You don't have to go to probate court. You don't have to file anything. You don't have to do anything. It just happens. And it does with financial accounts. If it's a joint account, the survivor owns it. Now, let's talk about a different family. Let's talk about Andy. Andy was single, but he did have a child, Opie. So what happens with Andy if he does no planning? Well, and we're going to consider that Opie's mom had passed away. We got her down here in the black box at the bottom. So Opie's mom had died. Andy's single, but he has the child. We still have to go to probate court. And we have to still do all the things involved with probate court. Probate court's a court of public record. So when those things get listed, anyone can see it. You can go to the courthouse, or for many counties, you can just get on your computer and access those files and see what Andy was doing with his money. But this time, after the creditors, now we know where it's going. It's going to Opie. So whatever's left is going to Opie. The problem is it will go to Opie at age 19 with no controls. Let's say Andy had amassed his net worth was $250,000. And when he died, that money would be held. Someone would have to be a conservator for Opie. That has to go through probate court again, a different case. That person has to be bonded. That person has to file a complete accounting annually with the probate court. Where the money went, what it was spent on, how much money came in, if any. And then OP, whatever's left, let's say $200,000, OP gets that check when he's 19. 19-year-old boy with a $200,000 check. Probably not a good idea, right? All right, so what if Andy had done a little bit of planning? He had a will also. All right, so then we still have to go through probate court. It's still public record. Anyone can go see it. We still have to pay the creditors first. But this time it can go to anyone. Andy can leave it to anyone he wants to. Of course, hopefully he leaves it to Opie. But in his will, he can say, I want this money held in trust if Opie is less than 25, or if Opie is disabled or incompetent for some reason. If he has an injury, an illness or something, and Opie is disabled or incompetent, I want it to go into a trust. And he needs to name the trustee. Maybe he picks Howard Sprague, the local accountant. Howard would manage Opie's money until he got 25. If he needed money for even living expenses, Howard could provide that. If he needed money for college, he could provide that. You can specify however you want that money spent or not spent. And that would be a much better outcome for Opie than him getting the check when he gets 19. All right, now let's look at a different family. Let's look at Howard and Marion. Howard and Marion had some happy days, right? All right, so let's say Howard, he's married, he has children. All of the children are with Marion, and he has minimal planning. By minimal planning, I mean that they have joint accounts. The house is joint tenants with right of survivorship, and all the financial accounts are joint. So what happens then? Or they're pay on death. So what happens then? Nothing. If all the accounts are joint, just like we talked about before, all of those things become Marion's in lawyer talk by operation of law. So she doesn't have to go to probate court. She doesn't have to do anything. All of it is just hers. She avoids the probate court. She doesn't have to pay, well, she may have to pay the creditors, but she doesn't have to have a publication. There's no public record. All of it goes to Marion. All right, what if Howard had some things in his name alone? Let's say Howard had a furniture business, and that furniture business was operated through an LLC. And his accountant and lawyer suggested that Howard make that LLC a single member, so it's a disregarded entity for tax purposes, so that it makes the filing of your taxes easier, makes operation of the business easy. But now it's not joint. So when Howard dies, that's in his name alone. So it doesn't automatically pass to Marion, which means we have to go through probate court. We have to provide the notice. We have to have the publication. It's public record. Pay the creditors. Supervision, close supervision by the probate court. And then, does it go to Marion? Partly. Marion, since all the children belong to Marion, all of Howard's children belong to Marion, she gets the first $50,000 and she gets 50% of the rest. So where does the other 50% go? It goes to the children, Chuck, Richie, and Joni. All right, seems pretty reasonable, right? But Chuck was out of the house. Chuck's over 19. So the business, Chuck figures, and is worth $650,000. So let's do the math. Marion gets the first $50,000. That leaves $600,000. She gets half of that. That leaves $300,000. Now Chuck wasn't on the math team, but he can figure a third of $300,000 is $100,000 coming to him. So he says, "Hey, Mom, when am I going to get my check?" And Marion says, "Well, son, look, the business doesn't have $100,000 sitting in the bank. We have inventory, we have equipment, we have accounts receivable, and I can't, it's an ongoing business. I don't have $100,000 to just write you a check. And so, we just can't do that. So Chuck thinks about it for a minute and he says, okay, Mom, so when am I getting that check? Now, if Chuck wants to be rude about it, Chuck can force Marion to pay him the $100,000, whether she has to sell inventory too cheaply, borrow money, and that could put the business in jeopardy, having to pay out $100,000 all at once. But if he wanted to, because there's no planning, he could do that. All right, now, what if Howard had done some planning, again, with a will? He would most likely just leave everything directly to Marion. Marion could help out Chuck if she felt like he needed it. Then she can take care of the kids who are still at home. So it would all go to Marion with some planning, even though he had things in his name alone that weren't joined. So then after Marion was gone, then it would go to the children, but only after she passes away. But of course, during her lifetime, if she chooses to help the children, she can anytime she wants to. All right, now let's look at a blended family. Blended families are not accounted for in the state's rule book, in the probate code. They make no difference and no account for a blended family. So let's think of a blended family. What about Mike and Carol? They had a bunch of kids, right? They had 3 each, and then they had a blended family. So let's think about Mike and Carol. All right, so what happens to this blended family when Mike passes away? All right, we have to go through probate court. Mike had no planning. So it'd probably be Carol who would be the administrator. Hey, Judge, I need to take care of my husband's business. He passed away. I need to wrap up the business and get things taken care of. So we still go through the publication, the public record, the inventory, the bond, all of those things. When we get done with that, Carol gets 50%. Because Mike has children that are not Carol's, she does not get the $50,000 extra. So then where does the other 50% go? Other 50% goes to Mike's children. Again, if they are below 19, they will have to have a conservator, probably be their mother. Let's say Mike had a business and half of the business is owned by his children and half by Carol. Now, do you think Carol is going to be able to get along with Mike's previous wife and the mother of his children? Maybe so, but maybe not. And now we're at 50%. And having to pay out 50% of the business is certainly going to be detrimental to any kind of ongoing business because he didn't have any planning. All right, again, no children with Carol, but they each have children. Carol dies first in this case. No planning, except that they had their bank accounts were joint. The house was joint tenants with right of survivorship. So when Carol passed away, everything went to Mike. Now Mike dies. So now what happens? Again, we go through probate court, publication, public record, bond, all of those things. Now where does it go? Does it go to all the children? No. Mike is not related to Carol's children. All of it goes to his children. 0% goes to the stepchildren under the probate code. That seems like a pretty unfair disposition of their assets. Think of this. What if it was a car wreck? What if Carol died 30 minutes before Mike died? And now Mike's kids get everything and Carol's kids get a 0. It can happen. If you have a blended family, you certainly need to have some planning. All right. What if he has some planning? Mike and Carol do some planning with a will again. Still go through probate court, publication, public record, all of that stuff, creditors first. Mike leaves it all to Carol. They built a lot together. Mike decides, I'm going to leave it all to Carol. Now, when Carol dies, does she leave it? Her will says first 50-50, right? That's what they make it. Whoever goes first, the other one gets it. Then we're both gone, it goes 50-50. But is Carol going to keep that? What if Carol gets married again? Statutory reasons that have to go to spouses. That's going to cut down their percentage. What if she just changes it? She doesn't have much contact with the boys anymore. Her girls go, Mom, you never see them. You don't need to leave them anything. You just need to give it to us, or you need to change your will, or you need to do this or that. And they may get left out. They may get their stuff. We don't know what's going to happen with that. All right. So now we've talked about dying. Let's go up a notch. Let's talk about incompetency. Let's talk about what happens if I'm single and I become incompetent due to dementia, stroke, Alzheimer's, or injury. What happens now? Well, state has a rule book for that. The probate judge and the doctor decide basically. A petition will be filed. It's public record. There's notice. There could be publication if we can't find all the people who need to be noticed. And it starts usually with a one-sentence letter from a doctor. I'm Blake's doctor, and I don't believe he can competently manage his financial or health affairs. And that's it. Then someone takes that to probate court. You can get an emergency order then. What if I want to fight about it? We have a hearing. We have a hearing because to see if I'm competent or incompetent. And that's a public hearing. People can come if they want to. And what's going to happen is whoever filed the petition, my son, my wife, are going to get up there and say all kind of things about me as to why I don't need to have my money or be making health decisions, right? That's going to be ugly because I'm going to be saying there, oh no, I'm fine. So that's that happens. So if someone is going to handle my money, they're going to have to be a conservator. They're going to have a bond. The bond is 150% of whatever the amount is usually. Again, inventory, list everything that I own. It's a public record. Now it's in the file. A lot of court oversight. You have to do the same as you would for a young person. Annual accounting, list where everything goes. Every single thing that gets spent of my money would have to be accounted for. And annually to the probate court. I have no control and I have no input because I had no planning. So whatever happens to me, if I don't have anyone to do it, the court will appoint someone. It will be someone I've never met, who doesn't know me, and is taking care of all my money and deciding where I live and even who gets to see me. It can be a bad situation. All right, what if I'm married and incompetent due to dementia, stroke, Alzheimer's disease, or injury? What happens? A lot of it is still the same as if I'm single. The guardian and conservator decide. My wife gets the first shot at being the guardian and conservator. The problem is all of the assets are available for the care of one. That may leave the spouse destitute or in a bad situation. If it's a blended family, the children, let's say it's Mike and Carol. Mike's children, one of his children would be his guardian and conservator. Now, is he going to care what happens to the girls? What if they own a house? Mike needs to be in assisted living. He owns half the house. If Carol can't buy him out, the house will get sold. And Carol will have to find another place to live. These things happen, and they're not good when these things happen. Lots of hurt feelings, lots of strife that could be avoided by some planning. All right, another notch. What if I have to go to the nursing home and I'm single and I require the nursing home care? Who's going to pay for it? Either I spend all my money paying for it, I have long-term care insurance, or I have Medicaid. Medicaid is the most common. How do I qualify for Medicaid? My assets must be below $2,000 and they must be spent down properly, meaning I can't give things away. I can't sell my house for $10. Everything has to be sold at fair market value. If I give away things, that would be an improper transfer and I'd be penalized for Medicaid purposes. That means that any money that I have given away, if I give away $10,000, that means basically that Medicaid would not pay the first $10,000 at the nursing home. Now there's some other math to it. It doesn't work out exactly to be that, but basically that's how it works out. So penalties are not good. Now what do my assets include? Includes my house, money, IRAs, 401k, stock, everything of value. My retirement plan is not protected. Life insurance is not protected. I have a whole life policy. Do I get to keep that? I do not. I can keep a car. I probably don't need to be driving if I'm in the nursing home, but I can keep that car. And I can keep a prepaid burial plan. And when I go to the nursing home, so that my burial is paid for. But that's the only two things I can keep. Let's look at some numbers. All right. If I'm single and go to the nursing home, I've got a house. Let's say the house is worth $150,000. I've got $100,000 in my retirement account, savings, checking, CDs, maybe an extra car, $50,000, and I've got a $50,000 life insurance policy. All right, what does Medicaid add that up to be? $350,000. All right. How much of that has to be spent before I become eligible for Medicaid? $348,000 is how much I lose without planning. It's a lot. All right, what if I'm married and I have to go to the nursing home? Same thing, assets have to be below $2,000, but in the beginning, they divide the assets in half. Half for me, half for my wife. My half has to be spent down to $2,000. Now, what does that include? That includes everything. What's mine is mine, and what's hers is mine. Well, what about her 401k and IRA? Yeah, that counts too. That's in the pot to be divided. What about her life insurance? Yes, it counts. Everything counts. But this time the spouse can keep the house and a car. But you kind of have to keep the house. A lot of times when someone goes to the nursing home, the remaining spouse may want to move into a smaller house, move closer to town, get something with less maintenance, less yard. But if you sell the house, now what do you have? You have money. Half of the money has to go in the pot. So you can keep the house, but you have to keep the house, basically. So that looks pretty ugly. So let's look at some numbers for this. All right, our home is exempt for this one up at the top. So we don't count that. We both work, so we've got more in retirement. We got $250,000. We've got a vacation house, a rental home, something of that nature, $150,000. Savings, checking, CDs, that sort of thing. We've got $80,000 extra car. Life insurance, we each have a $10,000 policy, basically designed for our burial needs. So we have a total assets of $500,000. All right, so let's look at some numbers on that. If one has to go to the nursing home, so we divide that in half, $250,000 each. The one in the nursing home, in the facility, has to spend $248,000 of that money, right? So you say, well, the one at home gets to keep $250,000. No, there's a limit. That limit is currently about $127,500. It's adjusted annually for inflation. So that means the one at home doesn't get to keep $250,000. The one at home has to kick in $122,500 of his or her money. So that means a total spent out of the 500 of $370,500. That's way more than half. That's more than 75% lost if someone has to go to the nursing home. And if the number goes above $500,000, This number doesn't go up, but this number will go up and the percentage lost will go up. All right, can I avoid these things? Can I avoid the probate court, the public record being published, waiting 6 months to distribute? Can I avoid those things? Can I avoid the petition for guardianship, conservatorship, the public record, the public hearing, the notice and the delay of all those things? Can I avoid my assets being down to $2,000 to be eligible for Medicaid benefits? Is there a way to avoid that? Well, hopefully that's why you're listening. Yes, there is a way to avoid all of those things and make aging and passing away much easier, possibly on us and definitely on our heirs. How to avoid these things? Well, you write your own rule book. I mentioned the state has the rule book of the probate code, but we can write our own rule book. Most of the time that's a trust. Sometimes it's a will. The will can change some of the rules. A trust can change virtually all of the rules to match what we need for our family, for our particular situation. All right, the two kinds of trust primarily. A revocable trust that we'll talk about first. The revocable trust avoids probate court. It basically replaces a will. It can provide protection from creditors after death because there's no probate court. There's no notice. There's nowhere for creditors to file to get the money. Now, I'm not saying this is a great way to beat your credit card companies out of the last payments, but it can happen that way. It can provide tax benefits. One of the big tax benefits is called the step up in basis. If you have an appreciated asset, such as your home, if you give it to a child now while you're alive, that child takes it at your basis. Let's say you bought the house for $100,000. You give it to a child while you're alive, that child takes it at a $100,000 basis. When you pass away, the child already has the house, sells your house for $150,000. So that child has a $50,000 gain, capital gain, which would be taxed at a minimum of 15%. So that's $7,500. Out of the $50,000 profit he made, $7,500 at a minimum would be taxed. But if the child does not get the house until your death, the child gets a step up in basis. So the child takes the house at the value of the date of your death, $150,000, sells it for $150,000. So there's no profit, there's no capital gain, and there's no taxes. Currently, you can die with if you're a couple, $23 million without any estate tax. If you're single, $11.5 million is the current number before you incur any estate tax. That leaves most of us out. All right, the other kind of trust is an irrevocable trust. Again, it avoids probate court after death and can avoid probate court in case of incompetency. Another important thing, B, it is not your money when applying for Medicaid. The trust is written in a fashion that it is not your money when applying for Medicaid, although you can still be in control of your money. We'll talk about that more later. Provides the same tax benefits. You put your house in the trust. If you bought Apple stock at $4 years ago, and now it's worth millions, but if you sell it, you're going to have that capital gain tax. You haven't needed it, so you're holding it. If you give it to your child now and the child sells it, capital gain taxes. If the child takes it at your death, the child takes it at the value of the date of your death and avoids all those capital gain taxes. Again, this one avoid claims on the estate. There's not an estate for anyone to make claims against. And so the claims would go unpaid if that were needed. There's no publication and no public record. Trusts are maintained in the family with the trustees that you choose. You don't file those at the probate court, and no one else gets to see them. All right, other things, the irrevocable trust can prevent changes in case of remarriage or incompetency. So if you, once it's in the irrevocable trust and one of you passes away, you can't change the beneficiaries. Before then, if you're both alive and well, you can change the beneficiaries. This allows you to provide for everyone in a blended family. Doesn't mean you have to leave everyone the same amount. You know, if you want to leave out any of your children, if you want to leave it all to charity, whatever you want to do, but it gives you the opportunity to ensure that the assets are divided evenly or equitably among all the children in case of remarriage or in case of a blended family. It can provide protection to your children after your death, protection from in-laws. If you have a child who's having financial difficulty, has filed bankruptcy, has judgments, liens, the money could stay in the trust after your death for the benefit of that child, but would not legally belong to that child, and so no one could get it. If your child is in the middle of a divorce when you die, and then the in-law goes, woohoo, hey, I'm going to get a bigger check now. Now that your parents died, look, you're getting that cut of that, and I'm going to get half of that. And you say, well, no, my parents didn't really have anything. Well, they had a huge house. We've been over there way too many times. Oh, no, my parents didn't own that house. What do you mean your parents didn't own that house? Oh, no, that house was owned by a trust. That trust was really nice. It let them live there for free. But no, my parents didn't own that house. I'm not inheriting anything from my parents. And so you don't lose any of it. Your child wouldn't lose any of it in that case. It also provides protection if your child is incompetent or disabled at the time of your death, or if your child predeceases you and it goes to grandchildren. We have other separate shared trust within the trust that protects the money in those cases. All right, with any trust, and especially the irrevocable trust, you choose the trustees. You can change the trustees as desired. If you get upset with one of your children marry someone that you don't like, they move to California, they move to Australia, whatever they do, you can change your mind. You can change your trustees. You can change the beneficiaries. You can change the amount going to each beneficiary. It's your money. You can decide where it's going. You can also decide who determines if you're incompetent without court intervention, without public record, or without publication. It's called a disability panel. You can choose your own. Now, it doesn't appoint you a guardian, but it does remove you from being a trustee of your trust and deciding where money goes. It can provide you from protection from winning the lottery in the Philippines. This is very important. You may have gotten a call today that you didn't answer, hopefully, that said, hey, you've won the lottery in the Philippines. All you have to do is send me $1,500 and I'll send you your $1 million next week. And so this is just representative of any kind of scam, because there are countless scams of people trying to take your money, especially from older people. So if you become incompetent, your disability panel, typically your children and your doctor, say that you can no longer manage your money. They can remove you from being trustee, and then you can't give away your money or be scammed out of your money. All right, so let's look at the effects of some of this on some of the people we talked about. Let's talk about Mike and Carol. Mike and Carol create a trust. It's bound by the trustees that they choose, 2 or more, with Mike and Carol's rules. All right, compare that to a power of attorney. Now, a power of attorney is a very valuable tool in estate planning. And most of the time, if you have a trust, you will also have a power of attorney. But then the power of attorney is more limited. Most powers of attorney are a blank check. You give power of attorney to your child. Child can take the power of attorney to the bank and say, hey, I want to get that money that's in dad's account. Here's my power of attorney. Oh, okay. Now they would probably say, well, we're going to have to send it to our legal department, but come back tomorrow. You come back tomorrow, they give you all the money. Does the bank call you and tell you about that? Probably not. If you're really good friends with the banker, maybe, but otherwise, no. There's no protection with the power of attorney. You give those controls up. Again, power of attorney is a very valuable tool, but standing alone, it can be very dangerous. All right, again, we're looking at Mike and Carol and their trust. All right, their trust does not go through probate court, does not go through creditors. It goes to anyone at any time. They put it in the trust. They need to advance the money to Greg to go to college, to start a business, whatever they want to do. It's their money. They can advance it to him anytime they want to. He doesn't have to wait till they die, but it's their choice. Goes through the trustees. Mike and Carol will likely be trustees. If not, other trustees could do the same. Mike and Carol choose the trustees. It's almost like having your cake and eating it too. Not quite, but as close as we can get. All right, we look at Mike and Carol's trust again. Mike dies. Now what happens? Okay, we still don't have to go through probate court. We still don't have to worry about the creditors. We don't do any of that. Now it's locked in. Mike is gone. Now the document states that now Carol can't make any changes. So when Carol is gone, it's going to go between Mike's children and Carol's children. No changes are possible after one dies. So it provides for all in a blended family. Carol gets remarried. See Carol's next husband? We got no lines going over here to him. Carol's next husband gets a big 0. If they divorce, 0. Carol dies before the next husband, he gets 0. She becomes disabled or incompetent, he gets 0. He's not in charge of anything. It's going to still go to these down here, to the children that they wanted to, the decisions they made while they were competent and healthy. So let's look at what happens if Mike or Carol went to the nursing home after having this irrevocable trust. All right, we have half and half of the $500,000, the same $500,000 we had. Mike has to spend 0 at the nursing home because it's in the trust. Carol doesn't have to contribute any of hers to the nursing home because it's in the trust. So that's $0 lost and 0% lost. That could be used for your family, college, legacy, whatever you want to use it for. All right. Another part of a planning could be a personal care plan. Now, if you have children that live nearby that you see on a regular basis, you're not going to need this. But if you don't have children who live nearby, or you don't have children, or they're somewhat estranged, and you end up needing care, instead of it going to someone you don't know, who doesn't know anything about you, you can create a personal care plan that states how you want to live if you have diminished capacity. If you go to assisted living or a nursing home, then this would tell the people who are going to be caring for you what you like, what you don't like, and tell some things about you. You leave a detailed plan of your wishes as where you want to be. I want to stay at home as long as possible, and even if care costs more to come to my house than assisted living, I want that. Or I would like to go to assisted living, and how you would like to be treated. Your likes and dislikes will be available for your caregivers and will be followed. You don't like mashed potatoes. I don't like mashed potatoes. So I don't want them to feed me mashed potatoes. I'm going to put that on my list. Do not feed me mashed potatoes. We also put on there, do you like to go to church? Do you not like to go to church? What type of church do you like to go to? Do you like to watch Fox News? Do you like to watch CNN, MSNBC? Do you like to watch sports, HGTV? Do you like to have alcohol, wine, beer? Do you want that? Do you not want that? So we can put in all those things that tells people what you want, what your life is like. And the more your life can be the same, the more monotony you have, the less your mental decline will be. So the more things you have that you like, that you're familiar with, the less your mental decline will be. All right. What are some benefits of planning that we've talked about? We've gone through that. Another one is it will feel good to have it done. How many times have you thought about it and you've talked about it? You go, yeah, I need to get that done. You see a TV show or a movie that involves someone dying in wills. You see friends dealing with their parents, having their parents pass away and talking about how difficult it is because they didn't have planning. Your family, when you're gone, your family will be grateful that you took the time to make the arrangements and plan. Your planning will cut down arguments later when you're gone, or even when you're incompetent. You'll save money. Going to probate court can be expensive. It's tedious, it can be aggravating, and it costs more money when you're gone. You can save some on the taxes through the step up in basis that we discussed. And you can brag about it. You're standing around in a group and it comes up, people are talking about it. Yeah, I've been thinking about getting a will or a trust. And you can say, hey, I've got mine done. You need to get on it. You need to get yours done. We've got ours done and we feel good about it. So you always have some social cred there. You've got yours done. All right, so the next question is, how much does it cost? All right, for me, that's the wrong question. The right question is, how much will this save? Proper planning could save your heirs many, many thousands of dollars and a big percentage of your estate. So the proper question is, how much will it save? All right, but the expense would be less than 1 month at the nursing home. And it would be not much more to do now than to probate a will or have a guardianship action. And they would save that money when the time comes if you have some proper planning now. All right, now since you've made it through this webinar, hopefully it was informative and maybe entertaining. Since you made it to the end, we will provide you an estate audit meeting in the office with me to discuss your particular situation and develop a plan for your protection, preservation, and your passing on of your assets. All right. And at the end of that meeting, the plan we develop, I will tell you the price. And that price won't change. And it won't go up, if you've ever been in the timeshare. Now, if you leave, it's going to go way up tomorrow if you don't make a decision and make a down payment today. No. I'll give you the price. If you make 15 calls to ask questions, then you make 15 calls. If you make 2 calls, it's the same price. It's a flat fee. There's no hourly rates. So you will know when you leave how much it's going to cost if you go through with this plan. And so we will send you an email with a link so you can set up your own appointment, or you can call us, 886-2372, Alabama Estate Planning Attorneys, AEPA, easy to remember. All right, so thank you for making it to the end. Thank you for viewing this. If you have any questions, you can call, email, set up that appointment, whatever you need to do. So again, thank you. And if we can be of any assistance to you, let us know.